Greetings, everyone. Welcome to 18th International Conference on Artificial Intelligence and Law. I am Aline McQueen, and this is the sixth panel of the second day of the event. Also, in name of the conference organization, I'd like to thank our platinum sponsor, Jus Brasil and Albert Einstein Israeli Hospital. Our gold sponsor, L'Algorithm, Legal Code, and PG Lawyers. And your silver sponsors, Urbano Vitalino Lawyers and Opsi Bloom Lawyers. And Ways is open. Now, I would like to introduce Mr. Hein Jane, who will present the full paper streaming with the title Hardness of Case-Based Decisions, a Formal Theory. Afterwards, we will move on the questions. The stage is yours.
Yes. Hello, everyone. My name is Heng Zheng. I'm a PhD student from the University of Groningen. Today, I'm going to talk about our paper, Hardness of Case-Based Decisions, a Formal Theory. Following precedence is a fundamental principle of case-based reasoning, but the application of it varies in complexity. Legal decision-making can still be very hard. This puzzle has been well recognized in AI and law since its early days. For instance, in Anne Gardner's landmark work, An Artificial Intelligence Approach to Legal Reasoning, she addresses the distinction between hard and easy cases by using ideas from jurisprudence. The hardness of case-based decisions can come in different types. Some cases are easier to decide. However, things can become harder. For instance, not all conflicts can be resolved, or there is no matching precedent. Significant work has been devoted to the nature and dynamics of case-based reasoning and to the hard cases as well. However, to the best of our knowledge, no formal theory about the hardness of cases has been proposed so far in the field of AI and law. So in this paper, we are going to discuss this question. Is there a typology of how hard it is to make a decision about an issue in case-based reasoning? We propose a formal approach written in propositional logic to formalize the hardness of decision-making issues with the validities of relevant arguments. We also illustrate the approach with a case study in the dynamics of case-based reasoning by following Berman and Hafner's research, thereby showing how hardness varies over time. This slide shows the 7 cases that we are going to discuss, which aims to solve tort cases about car accidents from New York. With the elements extracted from these cases, we got 7 conjunctions to represent them. They are represented by the plaintiff's name, the year of the decision, the kind of case, either a tort case or a contract case, and the jurisdiction choice rule. We need to consider which rule should be applied when different jurisdictions are relevant. For instance, when people drive from New York and have an accident in Ontario, Canada, which rule should be followed? Ontario's rule or New York's rule? Your territory is for entirely applying the territorial rule. Exception is for partly applying the territorial rule while making an exception for the damages part of the case. And gravity is for applying the center of gravity rule. In this paper, we try to apply our approach to solve problems such as if there are only these two precedents can be considered, how hard it is to apply the territory rule in an undecided tort case that arose after 1945. And what about the hardness of applying the center of gravity rule? And after new cases were added, does the hardness of applying rules change? And does it become harder or easier? In general, we consider these four issues of the New York cases, namely whether to apply the territory rule in tort case or not, whether to apply the gravity rule in general, whether to apply the exception about the territory rule, and whether apply the gravity rule in tort law. As you can see from this picture, there was an agreement in decisions that the territory rule should be applied in 1938, so decision-making was easy at that time. However, from 1945, alternative possibilities were explored. First is for contract cases, then also for a tort law case called the Cuba case in 1961. Therefore, case-based decision-making becomes harder since there are different possibilities and without a clear preference. And then in 1963, things again became easier since the landmark Babcock case expresses a clear preference for the gravity rule. Now we turn to the theory part of the paper. First, we are going to introduce case models. We describe a case model C as a set of logical consistent incompatible cases, forming a total pre-order that represents a preference relation among the cases. For example, the New York cases we just introduced can form a case model. And please notice that we consider the plaintiff names to exclude each other pairwise. And similarly, for the decision years, the kind of the cases and the rules. The preference relation among these cases is denoted by the size of these boxes. And namely, the Babcock case is more preferred than other cases, which are equally preferred. This is because the Babcock case is a landmark case that overrides previous cases, by which the center of gravity rule is established for tort law. And we consider an argument from chi to rho is a pair chi-rho, where chi is the full premise of the argument, rho is the full conclusion, and chi and rho is the full position made by the argument. According to the preference of a case model, arguments can have three kinds of validities in the model, from weak to strong, are coherence, presumptiveness, and conclusiveness. The relation between these validities can be illustrated by this Venn diagram. Conclusive arguments are also presumptively valid, and presumptive arguments are also coherently valid. And all the precedents are either coherent or incoherent. If an argument is incoherent, then it is outside the set of coherent arguments. Every argument can be attached to a label based on its validity in the model. An argument with a conc label are those conclusive arguments. An argument with a pres label is an argument that are presumptively valid, but not conclusive. An argument with a co-label is coherently valid, but not presumptively valid in the case model. And label inco is used for arguments that are not coherent. These arguments are in the set of all arguments, but not in the set of coherent arguments. We consider the validity labels come with an ordering. Intuitively, based on their validities, arguments with label conc are stronger than arguments with label press. Similarly, press is stronger than co, and co is stronger than inco. With this ordering, we can quantify how far apart the labels are. We call the validity distance between two arguments is the number of steps in the validity ordering that are needed to go from the label of the weaker argument to the label of the stronger one. As the ordering has a length 3, the maximal validity distance is 3, and the minimal is 0. For instance, from con to inco, the distance is 3, while from co to co, the distance is 0. With arguments and their validity labels, we can define issues for discussing the question about hardness. Formally, we represent an issue as sigma plus minus iota, where sigma is a sentence for a given situation. Iota is a sentence as an issue about the situation. Both iota and not iota are not logically implied by sigma. For every issue, there are two naturally associated arguments, namely sigma iota and sigma not iota. For example, when we think of whether to apply the territory rule in tort cases, we consider issue tort plus minus territory, where argument tort territory is for applying the territory rule, and argument tort not territory is for not applying the rule. Similarly, whether to apply the gravity rule in tort law is connected with issue tort plus minus gravity. Whether to apply the exception about the territory rule is connected with issue tort plus minus exception, and whether considering gravity in general is represented with issue tautology plus minus gravity. The type of an issue sigma plus minus iota in the case model C is represented as a multiset consisting of the validity labels of the two associated arguments. For instance, if the argument for applying the territory rule is with label conc, and the argument for not applying the rule is with label inco, then the issue tort plus minus territory is with type conc inco. And by the definition of arguments validity in our paper, not all types are logically possible. Now we show in total 7 possible issue types. And we view hardness of issues, of types of issues, as a relation between types of issues in different case models. Intuitively, a type of issues is easier than another one if and only if the greater the difference between the validity of its associated arguments, or the stronger the validity of the associated arguments. For instance, conc inco is easier than press, since the difference between conc inco is greater than the difference between press. And since the validity strength of press is stronger than INCO. We consider press is easier than INCO. As shown by the Haas diagram, in our definition, an issue type that is higher in the ordering is easier. Formally, the hardness ordering is based on the lexicographic combination of two orderings among the types of issues. We first compare the types in D ordering. Higher types in D ordering involve further validity distance between the labels within types. And higher in D ordering means the type is also easier. For instance, the validity distance between CON and INCO is 3, and the distance between press and INCO is 2. Therefore, by the D ordering, we consider CON INCO is easier than press INCO. However, if the types are with the same validity distance in D ordering, then we can turn to the V ordering. Higher in the V ordering means issues involving stronger arguments. Therefore, higher in the V ordering means the type is also easier. For instance, the validity distance of both type press and co are equal to 0. In this case, we cannot compare their hardness in terms of the D ordering, and we need to use the V ordering to decide which one is harder and which one is easier. Since press is stronger than co in the V ordering, we consider press is easier than co. The Haas diagrams in this slide shows our definition of hardness is well-behaved, since it is transitive and can be used for comparing any pair of issue types. Now we connect the hardness ordering with the development of hardness of applying rules in the New York cases. As we discussed before, the hardness of an issue is determined by the validity of the arguments that it associates with. And with new cases being added, the hardness of applying rules will change accordingly. For instance, the hardness of issue taught plus minus territory is with type CON INCO in 1938. When it becomes harder in 1963, it is with type press co. In general, we figure out that when the gravity rule was introduced in general in 1954, issue tautology plus minus gravity became harder. Similarly, when the gravity rule was introduced to the tort law domain in 1963, issue tort plus minus gravity also became harder. And we also observed that issue tort plus minus territory became harder correspondingly when the court showed doubt on the territory rule by making an exception for the damages part of a tort case in 1961. And in 1963, when the gravity rule was introduced by a landmark case called Babcock case, with higher preference, not only issue tort plus minus gravity became harder, but also other issues are become easier. After finally making the...
Hein, you have 5 more minutes, okay?
Okay. After finally making the gravity rule as the primary one in 1963, the 4 issues remain the same hardness type press co as in 1938, when the primary one is the territory, and they are all with type CON INCO. This shows that more options makes the consideration of applying rules becomes harder than in 1938. So in conclusion, we model the hardness of issues of case-based decisions in terms of arguments and their validities, and define an ordering that shows which issues are harder and which is easier. We also apply our approach to discuss the hardness of the issues in the context of dynamics of case-based reasoning. So the hardness approach we introduce is relevant in the understanding of case-based decision-making and can be applied in other domains where example-based reasoning is reasonable. And it can also lead to insights on the hardness of decision-making in hybrid AI systems involving both knowledge and data. Thank you for your attention.
Thanks for your presentation. We have a question. In the last part of your article, you have discussed the idea of the workings Herculean judge and counterpointed it with the existence of a variety of options to solve the cases we may have at hand. My question regards to the possibilities of more than one acceptable way to solve the case. Wouldn't this create a legal uncertainty in the courts?
Sorry, could you please repeat the questions?
Okay. In the last part of your article, you have discussed the idea of the workings Herculean judge and counterpointed it with the existence of a variety of options to solve the case we may have at hand. My question regards to the possibilities of more than one acceptable way to solve the case. Wouldn't this create a legal uncertainty in the courts?
Oh, yes. Thank you for the questions. That's for the, if I understand correctly, you mean there is a statement in our discussion sections. That's for the very initial observations of our approach. So I think that could be interesting for future research. Thank you. And I would also like to make a further response to one of the questions from my early presentation. It's from Professor Henry Prakken and about a paper from Thomas Gordon's 1991 paper and Prakken's 1993 papers. So comparing our approach to Gordon's work, our definition of issues share a similar intuition with his notion, but the mechanism behind our approach and his approach is quite different. And in Gordon's work, he simply distinguished cases into two categories. However, in our approach, there are 7 kinds of hardness. For Henry's work, he also connects hard cases with 2 arguments of which their conclusions are opposite, which is similar to our definition. But the purpose and the applied theory of his paper and ours are different. We have a special focus on how to formally identify the types of hardness, while it seems that Henry doesn't formalize the hardness directly. But we all still really thanks Henry's questions. It's very valuable to our further research. Yes, please. Now I'm ready for further questions. Thank you.
Thank you, Mr. Heng. Now I would like to introduce Ms. Lucia Zheng, who will present the full paper with the title, When Does Pretraining Help? Assessing Self-Supervised Learning for Law and the CaseHOLD dataset of 53,000 more legal holdings. Ms. Lucia Zheng, you have 20 minutes of speech. Afterwards, we will move on the question. The stage is yours.
Hi, thank you. Let me just share my slides. Okay, all right. Hi, I'm Lucia Zhang, a master's student in computer science at Stanford University. My co-authors are a team of interdisciplinary researchers at Stanford. Neil Guha and Peter Henderson are JD PhD students in computer science. Brandon Anderson is a data scientist, and Daniel Ho is a professor of law and political science at Stanford University. Today, I'll be presenting on our paper, When Does Pre-Training Help? Assessing Self-Supervised Learning for the Law. In this work, we aim to establish a set of NLP benchmark tasks for the legal domain and explore the conditions for which domain-specific pre-training may be worthwhile. It has been said that NLP has hit its ImageNet moment with the rise of large language models like BERT. However, curiously, existing work has reported marginal gains for pre-training large language models on law, particularly compared to the much more significant gains achieved by domain-specific pre-training in other fields, such as biomedicine and computer science. As an example, consider the core NLP task of text classification. The Chalkaitis work, one of the most comprehensive existing evaluations of pre-trained language model performance on legal NLP tasks, finds that the macro F1 gain of BERT pre-trained on law over base BERT is only 2.5, and the gain is even smaller for other tasks like named entity recognition. In contrast, the authors of the SciBERT paper showed that a BERT model pre-trained on scientific text with a custom scientific vocabulary achieves a 7.07 gain in macro F1 on a text classification task. It's worth noting that some of the large differences reported in related work like BioBERT compare BERT pre-trained at 1 million iterations and a domain-specific pre-trained model on top of BERT at 2 million iterations. And therefore, the result may be confounded by this. In light of work by the authors of Roberta, which suggests that BERT was significantly undertrained and can achieve higher performance by simply pre-training the model longer. We'll discuss how we address this issue more in our evaluation. So this all leads to the question, why have such large gains from domain-specific pre-training not been observed in law? We hypothesize that existing benchmark legal NLP tasks are not adequately difficult enough to satisfy the conditions under which significant gains from domain-specific pre-training can be observed. This may be due to the expense of hiring lawyers with legal knowledge to manually label data sets for difficult legal tasks. As a result, many private companies are unlikely to make investments in labeling unless it is for solvable tasks. So existing legal NLP data sets are not only small or proprietary, but also tend to reflect lower difficulty tasks that have been solved by methods often predating the rise of self-supervised learning and models like BERT. Armed with this hypothesis, we set about trying to construct a new large labeled data set for more difficult legal NLP tasks. As mentioned, this is often quite expensive due to human annotation costs. So we ask ourselves, instead of relying on expert annotation, can we extract signals from case law language in a systemic way to create a task? It turns out that the answer is yes, and this is because of one of the unique aspects of case law language, that it is stylistically governed by the Blue Book rules of legal citation, which set a standard for how legal citations appear in case law. This brings us to our key idea. We could create a multiple choice question answering task by leveraging these standardized rules to extract holding statements in case law. Holdings express governing legal rules when law is applied to a particular set of facts. They are precedential, which means they are what litigants rely on for subsequent cases. In case law, holdings follow legal citations and frequently begin with the keyword holding in parentheticals, as this format is strongly recommended by Blue Book. Using this idea, we created a new benchmark dataset, CaseHOLD. The next slide shows one example from the CaseHOLD dataset. On the left in gray is a citation and its citing context. We replace the location of the holding statement in the citing text with a holding token in brackets. On the right are the 5 multiple choice options for the citing text. The green boxes are incorrect holding statements matched with the citing text prompt, and the green box contains the correct holding statement that corresponds to the citation in the case law. This dataset has around 50,000 examples, comparable in size to other general domain NLP tasks, such as SQUAD and SWAG. To construct the CaseHOLD dataset, we extract all citing context, citations, and holding statements from a holdout set of the Harvard Law corpus, which is around 10% of the total corpus. We use the other 90% of the corpus for pre-training models, which we'll discuss in more detail in a few slides. Each example in the dataset consists of a prompt formed from the citing text and citation, one correct answer, which is the true corresponding holding statement found in the original text, and 4 semantically similar but incorrect answers, which are other holding statements sampled from the pool of all extracted holding statements. To match a prompt with 4 incorrect answers, we calculate the TF-IDF similarity between the correct holding statement and the other holding statements and match the prompt with the other holding statements with high similarity. We also set an upper threshold for similarity to prevent the matching of holding statements that parrot or paraphrase the true holding statement, which would make the task impossible. We also evaluate our model on 2 other benchmark datasets. The first is the overruling dataset, which simulates a binary classification task to determine whether a statement is overruling or not. This dataset is fairly small, consisting of 2,400 examples, and was created by CaseText, a company that collaborated with our team to release the dataset publicly. The second is the terms of service dataset, which also simulates a binary classification test to determine whether a consumer contract term is potentially unfair or not. This dataset was manually labeled by legal experts and contains around 9,400 examples. It was created by the authors of the Claudette paper cited on this slide. Next, we'll talk about the methods used to evaluate these legal benchmark tasks. To begin, we'll introduce the central BERT transfer learning paradigm, which we use to train our domain-specific models for law. This learning process consists of 2 steps. One is unsupervised training of large amounts of unlabeled text. In the case of base BERT in Devlin et al., the original paper, this is a general domain books corpus and Wikipedia. But as we'll see, this can be domain-specific text as well. BERT is pre-trained on this unlabeled text using 2 training objectives, masked language modeling and next sentence prediction. For the MLM objective, BERT masks random tokens in the input text and predicts the masked token. For the NSP objective, BERT predicts whether in a pair of sentences, the second sentence is the subsequent sentence of the first sentence in the original text. The second step is supervised fine-tuning on a specific downstream task with a labeled dataset. Using CaseHOLD as an example, we feed BERT citing text prompts as input and train BERT to predict the correct holding statement from the 5 answer choices. We trained several models using this framework. For our baseline models, we trained a 1-layer bidirectional LSTM initialized with 300-dimensional word-to-vec embeddings. For our baseline BERT model, we used the base BERT uncased model with 110 million parameters from the original BERT paper by Devlin et al. We also train a BERT double model, initialized with base BERT parameters and pre-trained for an additional 1 million steps on the general domain Wikipedia corpus used to train base BERT. BERT double provides us with a model that is pre-trained for 2 million total steps for direct comparison against our legal domain-specific BERT models, which are also pre-trained for that many steps, addressing the confounding issue discussed earlier. Legal BERT is initialized with base BERT parameters and pre-trained for an additional 1 million steps on the case law corpus, the 90% of the Harvard Law corpus introduced earlier. But it uses the same general domain vocabulary as base BERT. Custom legal BERT is pre-trained from scratch for 2 million steps on the case law corpus with a custom legal domain-specific vocabulary constructed using sentence piece on a subset of sentences from the case law corpus. With some initial exploration of model behavior, we can see the significant benefit of a domain-specific pre-training corpus and vocabulary for legal domain-specific reasoning. Let's take a look at a couple of examples. Here's a quote by Justice Marshall from Marbury v. Madison. "The very essence of civil liberty certainly consists in the right of every individual to claim the protection of the laws whenever he receives an injury." We can transform this quote for masked language modeling by masking out the last word, injury, and feeding this input to our BERT model. We would like the BERT model to correctly predict that the masked word is injury. We observed that base BERT and BERT double do not predict the correct completion within the top 5 completions with highest likelihood. I think base BERT predicts action and BERT double predicts emergency. But legal BERT predicts the correct completion, injury, correctly. This demonstrates that domain-specific pre-training on legal text significantly improves model accuracy for tasks for which the pre-training text provides relevant knowledge, in our case, case law. Custom legal BERT predicts correctly as well, though this is not pictured in the slides. As another example, take the definition of the word affidavit from WEX, the Cornell Law School Legal Information Institute Legal Dictionary and Encyclopedia. Here, we transform the input by masking the defined word affidavit and have BERT predict this masked word. We observe that our BERT double and legal BERT models predict that the most likely word is oath, which is similar in meaning, but not as technically precise as affidavit. Custom legal BERT, on the other hand, predicts the correct word affidavit and attributes high likelihood to this prediction. We see about 80%. Affidavit is in the legal domain-specific vocabulary for custom legal BERT, but not in the general domain vocabulary of BERT double and legal BERT. This suggests that the custom vocabulary contributes to additional gains beyond those from domain-specific pre-training only, especially for tasks that contain highly domain-specific terminology. We zoom out a little now to briefly discuss the details of unsupervised pre-training and supervised fine-tuning procedures we used for evaluation, and then we will present the results of the base setup and some variants. We use the pre-training procedure detailed in Devlin et al. With a few adaptations for improved performance on legal texts. One adaptation we implemented was a custom sentence segmenter that uses regular expressions based on Blue Book rules to keep legal citations together for next sentence prediction pre-training. This change was important because traditional segmenters use period characters as sentence delimiters, but there are many non-sentence delimiting periods in case law. We also used whole word masking for the masked language modeling pre-training objective. This change masks whole words rather than subtokens, forcing BERT to predict entire domain-specific terms, which are often not present in the general domain vocabulary and therefore frequently tokenized into subtokens. For fine-tuning, we use the input transformations presented in Radford et al., which allow us to train on different downstream tasks while making limited adjustments to the model architectures. Here, the green model box represents the section of the pipeline where we can slot in any of our previously described pre-trained BERT models. We'll go through the multiple choice question answering pipeline in a little more detail here, but the classification pipeline is similar. Using CaseHOLD as an example, we transform a particular example from the dataset so that the prompt is concatenated to each answer choice separately and separated by a start, delimiting, and end token. We feed each independently to the pre-trained BERT model we would like to evaluate, and this output goes through a classification head composed of a linear layer and softmax to produce a prediction of which answer choice is correct. The text below the diagram shows how this would be done for the original CaseHOLD example presented earlier. The following base setup results use this pre-training and fine-tuning procedure to evaluate the 3 benchmark tasks with tenfold cross-validation. We report average macro F1 as our performance metric. We observe that the baseline model performance for overruling is high. This is likely because the overruling task is comparatively easy. The task reduces to identifying the presence of keywords like overruled and disapprove in many cases, as these keywords commonly appear in overruling sentences. The baseline performance on terms of service and CaseHOLD is lower, which tells us that these tasks are more difficult and cannot easily be solved with a BILSTM or base BERT. We see that BERT double and legal BERT achieve marginal gains over base BERT for overruling, which substantiates our earlier hypothesis that existing legal NLP tasks may not be sufficiently difficult to observe significant gains from pre-training language models on law. We see that BERT double achieves much higher F1 on terms of service compared to base BERT, but that legal BERT is not necessarily more performant for this task. This is likely because though terms of service is a more difficult task than overruling, the task language is extracted from consumer contracts, which contains more common language and less language similar to case law. In contrast, there is a 5.7 gain in F1 between BERT double and legal BERT, which suggests that the CaseHOLD task is both adequately difficult and domain-specific enough to satisfy the conditions for which more substantial gains from domain-specific pre-training are observed. Lastly, we see that custom legal BERT achieves the highest performance on all three benchmarks. The F1 scores are bolded in the table. In particular, we see additional gains beyond just domain-specific pre-training from a custom domain-specific vocabulary, as reported in other domains outside of law. We also attempted to define a more quantitative measure of domain specificity, which we call DS score. It is computed by taking the average difference in pre-train loss between legal BERT and BERT double over the data set evaluated on the downstream task of interest. If a DS score is positive, this implies that legal BERT with legal domain-specific pre-training is able to reason more accurately about the task compared to BERT with general domain pre-training before any fine-tuning. These DS scores are reported in blue here. We see that the rank order of the DS scores matches our qualitative understanding of the domain specificity of the three tasks, with terms of service being the least domain-specific and having the lowest DS score, and CaseHOLD being the most domain-specific and having the highest DS score. We also evaluate the model on a few task variants. We discussed one of them here, and the rest are included in the paper. For the train volume variant, we vary the size of the CaseHOLD training set. This plot shows that legal BERT dramatically outperforms BERT double in precisely the setting that is relevant to law, where there is limited labeled training data. In conclusion, we present a new legal NLP dataset, CaseHOLD. This dataset illustrates the advantages of leveraging domain-specific knowledge, the standardized Blue Book format for holding statements in case law, to construct legal NLP datasets. Using CaseHOLD, we show gains from pre-training language models on law comparable to the largest gains reported by CyBERT and BioBERT. We hope this contribution drives excitement and interest in solving more difficult legal NLP tasks. Additionally, we outline two conditions that help identify where domain-specific pre-training may be worthwhile: task difficulty and domain specificity, and offer some ideas such as DS score about how to quantify these qualities of a task. This may guide practitioners in deciding when resource-intensive pre-training is necessary in the future. We close by sharing some resources. The legal benchmark datasets and the code for fine-tuning to replicate reported results are available at this GitHub link. We also invite you to download and explore our pre-trained language models for law on the Hugging Face model repository. You can explore model behavior using the Marbury v. Madison and the affidavit example from the slides, or any other descriptive examples of your choosing in the browser on the Hugging Face model pages. Thank you for listening. Neil and I are happy to take any questions, and our contact information is also on this slide.
Thank you, Ms. Lucia. And we have a question. In the section of related work in your paper, you have mentioned the possibility of selection of bias in available legal and NLP datasets, and this becoming one of the risks in the rise of self-supervised learning. What could be a solution of the control of the bias in the usage of self-supervised learning, and which are the risks we are facing with the non-usage of those solutions?
Yeah, so I think the question maybe is referring a little bit to the bias towards, let's see. Yeah, the bias of like towards simpler NLP data sets like being existing in the public, and the reason for that being that it is expensive to actually annotate legal NLP tasks specifically, because you have to pay lawyers with very expert like legal knowledge. And so one thing we sort of suggest in this paper that might help alleviate that issue with the cost is trying to extract signals based off the specific rules of like case law, or maybe based off any other formats of legal texts that are standardized, in order to do this in an automated automated fashion. And in that way, we can make large data sets much more cheaply for maybe tasks that are also more difficult, like something like multi-class classification or multi-label classification. So that can help. I think maybe another answer to that is more collaboration between these like companies and outside independent researchers, which may encourage like work towards that.
Thank you, Ms. Lucia. We don't have any questions, more questions. Well, now I would like to introduce Mr. Antonino Rotolo, who will present the short paper with the title, Modeling Legal Procedures. Mr. Antonino Rotolo, you have 10 minutes of speech. Afterwards, we will move on the questions. The stage is yours.
Thank you very much. I share the screen. Here we are. Okay. I hope you can hear me and you can see the slides. Okay, so this paper is a joint paper with Clara Smith, professor in Argentina, University of La Plata. And in this paper, basically, we try to provide to answer these two research questions. The first is how to model legal procedures. It's not a new research issue, of course. And second, how to handle priorities and related decisions in legal procedures. The layout of the talk is we will give you the definition of what the legal procedure is in a broad sense. Then I will present syntax and semantics for representing and for modeling legal procedure. And then I will show a couple of actions and logical principles for modeling. So what's a legal procedure? I mean, a legal procedure, in fact, is very similar to a workflow. So you have actions, a first action, then you have some intermediate actions and claims and responses by the authorities, and we have a final answer. So in a very short, in a very concise way, we can say that the procedure is a final sequence of actions, and the start is a first claim by the plaintiff, for example. Then we have, as I said, intermediate claims, responses. So we have claims and responses by the authority, by the decision maker, which are called resolution. Then you may have priorities among the options in the procedure. Then we have a last action that leads to a so-called individual norm, which is the judgment. Right. So the language we use for modeling this, I mean, there are other languages that are in the literature. For example, I did myself some years ago with Guido Governatori work where we proposed a language for modeling compliance in business process modeling. And actually, this was an option, but we tried to use a different language. The language basically exploits propositional and dynamic logic in a multi-agent variant of that. And we add some specific constructor that was originally developed in another context for modeling the violation of norms, and that was embedded within the PDL. So PDL in the version we use, adopts these expressions. It's basically a model logic with actions within the box. So alpha IA means that every execution of action alpha by agent I from the present state leads to a state where A is true. And then we have constructors that are some of the user constructor of proposition dynamic logic. In particular, you can build procedures using actions, and then you can have complex actions that are composed by the sequence operator. So P1 and Pi1 and Pi2 are two procedures that you can combine them in a sequence of procedure. You can have a choice. So basically, you have you have that pi1 is one option and pi2 is another option. And then we can have the third option, which is the preference. So basically you have two or more procedures or actions in the simplest case, and you can have a preference ordering among them, and you may have different preference ordering depending on the agent. So you may have a preference ordering for the plaintiff. Then it means that you have pi1 is preferred over pi2 according to the preference of the plaintiff, or you may have that the same as applied to the defendant in the case of the trial, and you can have a court as a preference ordering. So basically, you may have a number of different orders for each agent involved in the procedure. Typically, in the legal procedure, in trials, you may have defendant, plaintiff, and court. So the semantics is the semantics. So I will not spend time for giving the details. I would like just to draw your attention to the fact is the standard semantics for propositional and dynamic logic. So basically, you have a set of possible words, and you have a set of countable set of relations, each of them corresponding to an agent, and that you can have a way for defining complex procedures in a usual way. Then we have also the obligation. I will tell you more about that. And then you have a preference or a collection of strict partial orders over the set of the accessibility relations for the procedures. Then you have the model in a usual way, and then we have evaluations. The evaluation of formulae. So I just draw your attention to how to evaluate an expressional ID. That in the definition or the evaluation of an expression where you have pi1 all times I pi n, which means that you have pi1 as a first option, the first procedure, the first option in the first action preferred by agent I, but then you have pi2, pi3, pi4, pi up to pi n. And basically this is true if and only if you may have choice among them and you have a preference ordering coherent with the order of the pi or of the different procedures in the box. So it's a very simple extension of PDL where you basically have a box where you have a preference among the different actions in the box operator. And this allows for capturing the order among options in a workflow. And you basically have a parallel choice, and you may have an order between among the different options in the legal procedure. So, for example, suppose that we have this model, then you are in the state V, then we have different transitions. Transition correspond to accessibility relation alpha pi, then mu D and beta P and gamma pi and gamma P, and then in this model, this expression is true, provided that you have a preference ordering where alpha P is preferred over beta P, and which is preferred over gamma P, and according to the P preference. You may have different preference order, one for each agent. Then I will show you a couple of reasoning principles. I'm going to finish. For example, we impose a so-called procedural consistency. So it's not possible that if pi1 is preferred according to the court over pi2, and this brings about A, this implies that you cannot have the opposite, the contrary, the opposite preference ordering for any other agent, right? Why? Because if the court establishes that pi1 should be preferred over pi2, then this means that we cannot. This is true and cannot be put in question by the other agents. But except for the court, you cannot have. You may definitely have that two different agents have different preferences. So in other words, in the workflow, the court decides the options, right? Can settle the options in case of opposite views. Then we have also this principle, which basically allows for combining different ordering. So suppose we have A preferred over B, alpha over beta and beta over gamma. And then you have beta preferred over phi, and then we have phi preferred over psi. Then you may compose that you can say that alpha is preferred over beta, which is preferred over, and then you have gamma or phi, and then you have psi. The final criterion, the principle, and then I think I'm going to finish my presentation, is called detachment of obligation. This is meaningful only with weaker version of the PDL, where you can tolerate conflicts. In fact, you may have that alpha is preferred over beta, and that produces A, but you know that there is one possible transition that leads to not A if the alpha is performed by the defendant, which means that we have a conflict, but you can detach that the other option beta is obligatory. So at the end of the day, you have a way for deriving the obligation, provided that you have a sequence of preferences of the court. And the future work, and then I'm finished. I was mentioning the fact that we can have weaker logics. Actually, PDL is normal model logic, so it's would be interesting to explore a weaker version of this multi-agent PDL with the preference ordering, also the complexity issues. And of course, this work is preliminary in a sense that we just provided an idea, but still we have to check whether this language is adequate for modeling, for capturing several cases, and a significant number of cases of concrete application in the context of IAAIL law. Thanks a lot.
Thank you, Mr. Antonino Rotolo. And we have a question.
Yeah.
I really enjoyed the approach regarding the construction of the presented procedure itself on your paper. Which are your future perspectives in the construction of the application on the proposed machinery? Also, how important the presented principles shall be considered when analyzing the model itself?
Okay, thanks for the question. Well, in fact, one easy way for exploring the concrete application would be to see analogous application of PDL in different contexts. I mean, from the computational point of view, and in developing possible concrete application, there is a huge literature on PDL as applied, for example, on the ontic logic, for example. So, in fact, this is a very simple extension of PDL. Well, simple, not technically, I think it would be tricky, but you know, I don't think we are not so far away from the concrete application so far as the PDL was used, for example, in the ontic reasoning. So that the idea was to use PDL from the ontic reasoning into in the legal domain. And this precisely because the mathematical structure of PDL resemble very much to the structure of legal procedures. But so my first question is, we didn't so far too much, but I think there are a number of examples we can draw from the literature on the ontic logic. And this has to do with the first question. Regarding the principle, we provided just a few principles. But those principles are not particularly. I mean, there is one principle that I would like to say cannot be abandoned, which is the principle. The first principle I propose to you, the fact that you cannot have inconsistency in the case of defendant and plaintiff, between the plaintiff or the defendant and the court, because in the machinery we develop, basically the court is a way for superimposing and for solving possible conflict between the preferences of the different parties that are involved in the legal procedure. This is, I think, the only principle that I would like not to abandon. The others are absolutely can be developed. And by the way, it's also would be also very interesting to explore weaker version of PDL, which I think is an open question that I think is not yet explored in the literature enough.
Thank you, Mr. Antonino Rotolo.
Thank you.
Now, I would like to introduce Mr. Livio Robaldo, who will present the short paper with the title Compliance Checking in High-Field I/O Logic via, one moment, via SHACL. Mr. Livio Robaldo, you have 10 minutes of speech. Afterwards, we will move on the question. The stage is yours.
Okay, thank you very much for the introduction. Yes, in this paper, I'm trying to present an approach to use verified input-output logic to use it for compliance checking via SHACL. And actually, this is only the tail of a research endeavor that I'm carrying out since more than 5 years. I started at the University of Luxembourg in order to combine natural language semantic, deontic logic, artificial intelligence law, and IAAIL RDF. And my plan is to use reification as the main formal instruments in order to glue all together, to use them all together, because all these 4 topics has been investigated in different research. What I would like to do is to carry out all together, to keep a fit in every strand. And on the wake of the transition from machine learning to symbolic approaches for AI, this is, you know that explainer artificial AI is becoming very popular nowadays. So this is my contribution to the field, and in particular in the field of artificial intelligence and law. And reification, as many of you know, is a philosophical concept that was firstly introduced by Donald Davidson, who was a philosopher and in natural language semantics, and is a technique that consists in transforming something that is abstract, like a relation, a predicate, into something that is concrete. So basically, we associate predicates with constants or variable in first-order logic on which we can assert other predicates. And reification is a very popular technique, so that nowadays there are several hundreds of neo-Davidsonian approaches to natural language semantics. And the one that I adopt is the one authored by the professor in the middle of this picture, that is Professor Jerry Hobbs, that his theory is a theory of natural language semantics is grounded on a massive use of this reification technique. And so, for instance, in Hobbs logic, we flat everything, and that's the magic word is flat. We transform everything into a flat conjunction of atomic predication. So even if a sentence, John knows that he cannot fly, that in standard logic can be represented with something like this, in which we embed, we encapsulate the operator, the model and the Boolean operators within one another. In Hobbs is all flattened in a formula like this that reads, it really exists an event on knowing that is performed by John, and in particular John knows this other event. This is the fact that something else is not existing. This something else is the fact that John is doing a certain action. This action is the fact that John flies. So this is how we read this formula. And as you can see, we reify even the Boolean connected. So the only, this is first order logic, but actually is a fragment of a very limited fragment of first order logic, in which the only Boolean operator is the conjunction. And then on parallel, you know that there are several approaches to deontic logic, and in particular there are approaches that are called norm-based, that try to model deontic logic in terms of if-then rules that state that if something exists, then something else is obligatory or permitted or something else is entailed, so we have a constitutive rule. And the most popular norm-based deontic logic is this input-output logic, authored by my supervisor in Luxembourg and David Mackinson, and so that input-output logic is basically represent the deontic rules in terms of flat set of if-then rules. And again, the magic word that suggests to integrate the two together. This is what I was working in Luxembourg, where I proposed this new logic in which we basically combine the logic of Jerry-Ops with input-output logic in order to move beyond the propositional level, because before that, input-output logic is only studied at the prepositional level, but this is not expressive enough to represent natural language semantics. So my idea, let's use replace propositional logic with the logic of Jerry-Ops and use reification in order to flatten complex operator that in standard logical approach requires embedding of subformula within other operators. Here we flatten everything, and the idea is in this way that we can build a larger repository of norm from existing legislation which is available in natural language. And so here we have an example from the GDPR. This article that is basically states that every personal data processing has to be lawful and is formalized with respect to this if-then rule. This is an if-then rule in input-output logic stating that for every personal data processing, so for every event that exists at time t1 and there is it is a personal data processing between X and Z, and X is a processor and Z is a personal data of the data subject W, then it is obligatory for this processing to be lawful. Okay, everything is formalized like this, and we reach the standard input-output logic with this first-order reification-based approach in order to model more easily natural language statement. And in particular, we want to do them quickly because legislation is huge. We have to build this repository quite in a short time. And this is what I did in another project at the University of Luxembourg, in which I translated the whole GDPR in reified input-output logic together with Monica Palmiani. In this project, I worked with Monica Palmiani. In particular, she developed an ontology that is called Pronto for the GDPR, and then I used the concept of Pronto in order to model the norms in the GDPR. And if you are interested, the knowledge base is available on the GitHub and described in that journal paper. Now, coming back to this is what I did so far before this paper, but as you can see, there is a missing ingredient in which is what I work in now. Because as also my dear friend Guido Governatori always has a kind of morbid pleasure to underline, is that reified input-output logic is a wonderful theory, but it's just a theory. So for now, we only use it to represent them on paper, but we cannot reason because no automatic reasoning currently exists. And it's right. So you can see also my disappointed face on the right. So that the idea is to transform everything, so the ops logic to implement in RDF in IAAIL in order to use the reasoner that are already available for RDF in IAAIL. Because also, RDF models, again, the magic word, into flat knowledge into flat sets of triples, so that there is a direct mapping between the logic of Jerry-Ops into triples in RDF. And so for you I guess you know that so this is the interface of Tobriad. We can take any statement in IAAIL in RDF. We can reify with the interface, for instance, of O'Brien to represent, to introduce a new variable that, a new constant, sorry, that refer to the event, to the statement, for instance, here in this example, to the fact that in Italy, the minimal age for consent is 14. And In parallel, what I want to do is, besides formalizing GRIOPS in RDF triples, then we have also to model the if-then rules, so to connect the antecedent with the consequent. And for that, I'm planning to use this shackle, that is a new recommendation for W3C, that will allow me to implement these if-then rules, to implement both obligations and permission and other constitutive rules. And here now, this formula, of course, a bit complex. You can have a look in the paper, in which I extract a fragment of Pronto, and then I defined a kind of initial methodology in order to formalize some selected if-then rules from the data knowledge base in this shackle. And you can see, for instance, to check lawfulness, to implement the if-then rule, the refined input topology formula that I showed you before, we write this shackle shape, in which it requires that if there is a personal data person, this personal data person must have the attribute is lawful as true. And this is not something that is asserted. So this is something that is checked. And if when a shackle is executed, shackle tell me that this ontology, in particular with respect to this individual, to this personal data processing, is not valid because it doesn't respect this shape. And this is the way in which we can implement obligations. Okay, because you know that obligations are not inconsistency. So the ontology can be consistent, but still we can have some violations, like if the value of this boolean will be false. And here in an example on how we implement a constitutive rule, because here it says, here there is a rule that says that if there is if the data subject has given consent and there is not this exception, now I don't have the time to detail about that, but you find it described on this paper. The exception says that the data subject has not to be a minor. So it basically says if the data subject has given consent as in not a minor, then assert is lawful as true. And then if this constitutive rule triggers on the ontology, this boolean is asserted as true, and then this obligation, of course, that is satisfied. So the ontology is validated with respect to the obligation modeled in terms of shackle shapes. And this is what I'm working now. Any of you is very kindly invited to join me if you're interested in shackling refined input output logic. And that's all. Thank you very much.
Thank you, Mr. Livio Robaldo. We have a question. Firstly, I enjoyed explanation and the correlation of the compliance and the deontological reasoning. My question regards the given explanation of the deontological reasoning, as we faced the idea that compliance can take into consideration good practices, norms, which don't necessarily bind the parts. How we have to face this possibility when analyzing your model?
Yeah, this is exactly what I'm working now because in the slide I showed an example of exception that are hard-coded in the legislation. What I'm working now is to work on legal interpretations and argument of the several concepts, because okay, to check if a data subject is a minor, this is quantitative. You look in his ID, and if he's beyond a certain age, is not a minor, otherwise he's a minor. But of course, there are many other concepts that can be subject to legal interpretation. So we can have, as is written, as is asking in the question, someone that can have an opinion and someone that can have a different opinion. Then it is up to the DPIA, to the Data Protection Authority, to take a decision in the case of the GDPR. In case of other other norms, it will be a judge in the court. And what I'm doing now is to model legal interpretation in terms of other concepts and also arguments and all what we need in order to support a certain legal interpretation. And so that we can encode within the ontology also the good practice, the recommendation from the DPIA, and also including the decision. We can, when there is a conflict between norms, there is an authority that is summoned in order to take a decision about the conflict. And the decision is supported by argument. All these can be represented in terms of our concepts. And this is the way I would like to do. And so that you can have a different form of reasoning according to the legal interpretation that you select. Then certain authorities will override other authorities, so the reasoning will be again deterministic. In case we have two authorities that state different conflicting opinions about the same, we will have a non-monotonic reasoning, but this is what happened in reality, and so is fair to model the same also within the ontology by the artificial intelligence.
Sure. Thank you, Mr. Livio Robaldo. And thank you to everyone who participated in this panel, and we close for today. Tomorrow, we will have more presentation from 9 p.m. and 9 a.m. GMT. Thank you very much.